to Tautau, or Te Rangatira, or Te Kaiwhakawa, Whangatil stands for the honour of the judge. Family court is now open at the matter of delay, with Puritan and Grace.
Sir, in regards to my property, I'm speaking as the executor of my estate, the Philip Sassoon Sally Estate, General Executor. Your court says here, Judge Drewsman making all these orders on me on the 15th of April, the court has no jurisdiction.
Could you take a breath so we can have a bit of a conversation about this before we start? Do you have someone with you as support person?
I do, sir, to be a witness too, because these cases have been held behind closed doors. The transcripts of the hearings are completely incorrect and do not match what we say in the court. Therefore, I do ask that we have a witness.
Don't be difficult there, just I was asking one example who he was.
Yes, Ken Franklin, sir.
Do you understand the rules about Mackenzie Friends?
I do. I have been Mackenzie Friends before.
So, now, Mr. Slade, just to you, there's a few things I want to make you aware of because they're somewhat complicated today's hearing. The first of which is your application for the waiver of the hearing fee is lodged in Kaikoa. I don't know why, but it didn't come down to on April the 10th and wasn't brought to the attention of Judge Lindsay, who you may or may not have caught up to this, but the initial hearing was this afternoon, then it was scheduled for 11:45. As far as Judge Lindsay knew, and I appreciate that it's got my name on it, but it was seen by Judge Lindsay, the hearing fee had not been paid and she wasn't aware of your application. So the last minute that she issued, or that was issued as directed by her, was issued, I think it may have been when it was late this morning, but it was to the effect that today's hearing, 16th February, was vacated. Ms. Robertson was granted leave to withdraw, and the matter was scheduled for a registrar's review on the 20th of February at 9 a.m. Mr. Slade finalised the payment of the filing fee and made the submissions as to further direction as to the prosecutor's application. In the event no steps taken on Mr. Slade, the court will consider striking out his application. So, as of now, it's 11:45 to start with, the last thing issued to the court was advised at least to, I think it may well be on your email, feed it is, ended 8:42, and it was sent to Ms. Robertson as well, so that hearing wasn't received.
Sir, I object to that. I object to filings being sent the day before the hearing. I object to the court making announcements just before a court hearing. The court has had plenty of time, 2 years in fact, to do these procedures. There's a property relationship that should have been held within 42 days under the Domestic Violence Act, taking my property without jurisdiction, as Judge Maud said. This court has no jurisdiction over my property, sir. Over the property of Philip Sally Estate. It has no jurisdiction over the property. Your judge, sir, your judge on the 16th of July made a consent order for my property. That was treason. I've signed no consent order. No consent orders have been signed in this court. The judge has used that consent order then to withhold my property now for 2 years. Okay, that's my personal property, not just, we're not just talking auxiliary furniture here, we're talking personal property, absolute property, joint property, my grandfather's war medals and heirlooms, property that cannot be replaced. It needs to be returned and returned to me today, sir. I'm not going to accept this court cancelling hearings and the skullduggery that's been going on in this courtroom with a lawyer filing the day before the court and making the court, the family court will say, in the court closest to the parties, which is Kaikoa. So you make the hearing over here, send the email at 9 o'clock in the morning, knowing that I'm on my way to Whangarei.
Look, don't hear me to say this is best practice, Mr. Slade. I'm not terribly happy that I find myself...
Well, I'm not terribly happy, sir. I've 2 years about my property living on the street. I'd like it back, please.
I understand that. I want to explore with you how we get past the difficulty, because I don't think it's satisfactory that it got to this point, but I have the problem that as at 8:42, an advice went out from this court to the effect that the hearing would not be proceeding. So in some way I must make sure you appreciate that both sides are heard. So in that respect, I'm in some difficulty. I've had a look at your application for waiver of the fee, And in the ordinary course, that would have been granted, but of course it wasn't received by anybody to deal with the undistributed land until later in the piece, and it wasn't drawn to Judge Lindsay's attention, so she didn't have that benefit. So it's a question of how we make sure that people do get the right to be heard.
So I've had 2 years to have the right to be heard.
I understand.
And I'm not going to accept any more avoidance. I've had to pay a stack of bills that this court has run up on my property: unpaid mortgage, unpaid rates, unpaid insurance, and I've had to pay all these bills that this ministry has run up on Philip's property without jurisdiction. And the first judge says you have no jurisdiction to this property, and you've continued to withhold this property for 2 years, not upholding the law, sir.
Well, can I ask you, Mr. Slade, the last advice we had from Ms. Robertson, the 13th of February, said that there was a default notice issued by the mortgagee, by the bank.
That was correct, because the mortgage had not been paid.
Right, it had not been paid since October of last year. Well, September, there was
And that was 2 years' rates as well to add on to that, sir. I have confirmation here that the home loan has been paid in full, if you'd like to see it.
I would be interested to see that. Are you back in occupation of your home?
Yes.
Right. How long have you been in occupation?
Since I got this order from Judge DeRitter on the 13th of November, discharging the variation order, keeping me from my own home.
So you've been back the 13th of November?
Yes, sir.
And which one of these is the one that tells me?
Well, there's the online banking statement, sir, because the account has been closed. There's a letter of foreclosure of the account in there, sent to the bank. There's a receipt of payment to the bank in there as well, sir.
Right, this is a letter dated the 19th of January. You writing to the bank saying, please settle the account from, this is the full balance of the
As it's more than the full balance, sir. The full balance of the account was $140,000. I provided $375,000 to the bank and asked them to take out their fees and their interest and anything else they were going to throw at me, thanks to the ministry. And I resolved the issues with the bank. The bank said the account has now been foreclosed. There is no more joint account between myself and Miss Curtin-Griffiths. I would say that now Miss Curtin-Griffiths owes me half of the property value, unless she decides to sign the house over to me as she agreed to do so some time ago.
Okay, so I don't quite see in that where there's an acknowledgement from the bank. It's a promissory note.
They were paid by a promissory note under the terms and conditions of the New Zealand Bills of Exchange. The bank accepted the promissory note. It's got a stamp on there delivered by the post office. There's no discrepancy, and the response from the bank was to close the account.
Where's the advice from the bank that they close the account and receive the money in full?
So that's a printout this morning from my bank accounts. There you won't, you not see any home loan on there, sir. All they have is my single loan and my insurance. That is my total, or mine and Curtin-Griffiths' total accounts with the BNZ. And there are reasons why the BNZ are behaving somewhat mysteriously. That's another issue, so that comes under the Bills of Exchange.
So those funds, the $375,000, that document, the promissory note?
That's a receipt, sir, yes.
Right. Where did the money originate from?
Same place as the mortgage money came from, sir. If you read the email, the bank tells me that they create the money out of fresh air for my signature, and then they sell that bond on the stock market, then they pay for my house, and I end up paying them back with real flesh and blood. And that's not an issue for the court today, sir. The Bills of Exchange will be discussed in the Supreme Court. I took my money into the bank and I asked them to exchange my $10, and the bank said they could not exchange it for anything. They didn't even know what I was talking about, sir.
No, the reason I asked Mr. Slade is this: if the bank's action under the mortgage there's any accepted this payment and tendered it, then in terms of urgent issues, I appreciate everything you tell me that you say is long delayed and long past urgent, but the bank's urgency has been satisfied because they've received
more than ample, sir, to pay back.
What is it that you've given? Because what that looks like is a note that you've generated yourself.
That's exactly what it is, sir.
Well, I mean, in modern banking terms, the bank won't have said that you're authorised to issue credit to yourself.
Sir, I think if you read the bills of exchange, and I will happily do this in the Supreme Court, that fits the criteria of a promissory note, exactly to the letter. Delivery is acceptance. It was sent to the legal department down in Wellington of the BNZ Bank, and it has been accepted. I went into the bank, and she said they will be forwarding me a foreclosure notice of the account. I printed out that bank statement this morning to show you that there's no more account, no more debt on my property. And I have to wait for the notice from the bank. But that is a printout from this morning showing that my home loan account no longer exists.
Did you accumulate $375,000 in the old traditional way when you lodged money to your credit in an account?
Legal tender, sir.
Yeah, I know you say that, but...
No, I'm not just saying that, sir. That is legal tender on the bills of exchange. I had the bills of exchange. If you'd like to protest any part of that note, I'm quite happy to do that with you, sir. I have the bills of exchange here. If you can tell me which part of that note you protest, we'll have a look at the bills of exchange.
I'm not protesting it, Mr. Sloan. What I'm trying to understand is whether, in fact, you have given the bank $375,000 on terms that they accept, because...
Sir, delivery is acceptance.
Well, if I follow that logic, then presumably you could generate a further promissory...
Absolutely, sir.
Any amount of...
Exactly like the banks are doing, sir. I could do exactly the same.
But you're not a bank.
Sir, you don't have to be a bank. Here's the bills of exchange here. Acceptance means... Sorry about my glasses. An acceptance...
Hold on, Mr. Snow, you've got some other people at the counter who say they're with you or support us.
Well, they wanted to witness this today in the court, sir, because we're just finding it really unfair and unjust. Acceptance means...
Mr. Franklin will need to report to them because I don't know...
Can I invite them in?
Pardon?
Can I invite them in?
No, that's what I'm saying. I'm happy to have you as a Mackenzie friend, but I don't know how many are out there, and I don't know what the connections.
Well, sir, the public are writing letters of protest.
One at a time. Mr. Franklin, you identified yourself as a Mackenzie friend of Mr. Stillard.
Correct.
You can bear witness to what goes on here, and you've heard what I've said so far. I don't take the view that we need a number of others within the courtroom for that purpose. So, I understand Mr. Slade and other supporters that you'll need to report. He's welcome to report back to them on what he said today and what I said. And there is a transcript that is kept and maintained.
Correct.
So, if you could ask them just to forward to take a seat and Mr. Slade will be free at 1 o'clock. All right, so you say that's legitimate, and I'm not...
It has not been protested, sir, since it was given.
No.
The bank closed the account. They're going to forward me documentation. There's no 800 number on there if you'd like to ring them for yourself. I can't do any more than that this morning. As I say, the best I could do was get a printout off the computer because that come all the way to Pongaray.
Well, for my part, you understand, I'm still apprehensive that the bank might regard themselves as holding security over your property. It might still regard you as requiring to pay the amount outstanding, and that creates some urgency in my mind. This is resolved. If you haven't been paying the weekly sum since November, you told me the 13th of November, then this mortgaging notice will take effect on the 26th of March. At that point, the mortgage sale process will follow. And I see the rates that have been paid either. That's unfortunate.
Well, it's not unfortunate, sir. It's actually unlawful leaving me all those rates on a home that the ministry took and didn't pay their bills.
Well,
Sir, and that's the reason why the mortgage never got paid, sir, because you made me lose my job, sir. And you've got all my portfolios, and you've got my CVs, and you stopped preventing me from working for the last 2 years, putting me on bail. And as Judge De Rita said in court the other day, when I went to district court, he said, Mr. Saleh, There's no history of violence, and there's been no acts of violence. But sir, I must remind you, on the 15th of April, you have been using the Domestic Violence Act to destroy my daughter and my life. And you're fully aware of these matters, sir, because they've been sent to court in the memorandums. And you're completely aware of all the laws that have been broken up to this point, sir. And the alienation of my child, which you know, sir, is against the international human rights to alienate people's children. Now, Mishka Sally is also my property, sir, and I have brought here a letter from Internal Affairs, which I'd like you to hand to the judge, please, to show that my daughter is my property, and you have no entitlement to her. Because we are having a property hearing today, sir. Can you pass that to the judge, please?
You and I, Mr. Soleil, are going to disagree about that.
Sir, there's another document here I'd like you to see. This is private and confidential.
I don't doubt you are Mr. Soleil's father, but the notion that this is your property and that
and as a general executor of Mishka's estate, I am ordering you as my trustee to return that child. She's my property.
that's not the purpose of today's hearing.
Sir, she's my property. This is a property hearing.
She has not come within the definition of property under the Property Relationships Act, and I will not be making an order for her return. What I was trying to engage with you about the difficulty that I had by reason of the fact that Ms. Griffiths was told late that there would be no hearing, and I understand you all seem so grievance about the delays and the fact that have gone wrong, as you say have gone wrong. We are not going to deal with Mishka as if she was a chattel. So that's simply not.
Well, sir, she has been used as a chattel. As you can see, there's a registration document which I did not sign. I didn't register my daughter to your ministry, and my wife did not register my daughter to your ministry. My child was born. She certainly could not sign a document to register herself to the ministry. Therefore, her probation papers are there, and under the trust, I'm requiring you as my trustee to return my property, sir.
You've confused a whole lot of concepts, and short of making. If you want to waste the time that you have on this issue, you can, but I can tell you now that I am not a trustee of any trust. This document that you've tendered me, which says to be a Chancery Equity Special Appearance Legislative Appointment, in the limited time, I have to say I don't recognise its authority.
Well, sir, under the Editorial S99, in conflict between common law and equity law shall prevail, sir. That is equity law, and it should prevail, because it's more honest.
This isn't common law. This is the statute-based system under the Care of Children Act, and the rulings that have...
Well, sir, you're making district court rules on me. You're having these hearings in closed courtrooms, without anybody being able to witness what goes on in these courtrooms, sir, and you're making district court orders, and to have a district court hearing, you need to have a judge. I have the choice of a judge and jury. This has never happened. I never even got a trial for 8 months with yourself, sir. 8 months you put these orders on me, and 8 months you kept my child on my property before I even got a hearing. Now, already you're in breach of the 42-day rule, sir. You didn't provide the S1, 2, 3 reports. You didn't provide the supervised contact reports, all in that judge's first order, sir. You've broken every rule in the book, sir. And you were the judge on the 11th of December, sir, alienating my little girl on my property, sir, making more orders against me in a district court order, sir, in a family court, closed court, without anybody being able to witness what's going on, sir. Only with your court contractors in the courtroom, sir. No one else is allowed in.
I must confess, Mr. Snail, a lot of what you just said I don't understand or accept.
Well, I have written it out in memorandums as clear as I can, sir.
No, but the fact of the matter is, if you had checked, you would know that I was only appointed on the 24th of October of last year, 2014. So whatever preceded that was not something of my making.
Sir, you covered the other judges. When Judge Maud said he had a consent order, you backed him up in your minutes. But you cannot produce that consent order, sir. It was not in the bundles, and that is a breach of the Evidence Act.
Mr. Lay, the purpose of today's hearing, as directed, was to respond to your application for property orders, correct?
Yes, and I'd like my property back today, sir.
Well, I'm not in a position to accommodate that because through a series of administrative processes, today's hearing has been vacated. What I want to try and do with you is to work out how best to get this back on track. I have read where property, in the terms that I would define property, by that the home, your home at Rowan, the chattels, I've seen the exchanges between you and Miss Robertson about that, and it seems to me that they have been saying that if it was a matter that could be resolved by
sir.
Section 21, I think.
I have no confidence in any of your sections, sir, because you've broken so many that we actually, what's the point? I mean, what's the point of having legislation or acts if the court did not follow the acts, sir? And if you had followed the acts, we wouldn't even be at this stage right now, sir. If the law had been followed, failure to maintain the consistency of the family court rules, no case should be heard. You failed that on the 15th of April 2013, and you've continued up to this day, sir. And you're going to continue with another act and another excuse, but at the end of the day, my property has been stolen, you had no jurisdiction, I would like it returned today, please, sir. And that is not auxiliary furniture we're talking about here, sir. And in Miss Keeling-Griffith's affidavit, she says the house was empty. We have police photographs, which I sent a couple to the court, which show the house was not empty. Miss Keeling-Griffith says in her affidavit that she didn't serve without notice protection orders and occupation orders and all the rest of it. We have piles of documents saying without notice, occupation orders, protection orders, parenting orders and all the rest of the things that you did to me, sir, without notice or a trial or a hearing or an offence. And as Judge says, there's been no history of violence and there's been no acts of violence, sir. So I'm at a loss how you could be using the Domestic Violence Act to withhold my property for 2 years. And the costs, sir, obviously, of holding my property in my CVs needs to be accountable. There are huge costs involved in this.
You sound to me like you're raising allegations as against the
procedure, sir.
Again, not as against.
Well, sir, these acts are meant to be followed, and when the court breaks the act, nothing's done about it. And I just don't see that, sir. I don't see how a judge can just break rules and break laws and break acts and then just override it and it's never addressed. I just don't see how that's possible. So what law are we under here, sir, today? I don't know. Common law, admiralty law, equity law, or some other kind of law that we don't know about because you haven't followed the judicial process that the court is required to follow at any stage, sir.
Here because you commenced a proceeding.
No, I'm here because you took my property, sir, on the 15th of April, your ministry did, and I would like it back and returned.
On 2013?
No, 15th of April 2013, all my property was taken by the court.
You've asked for, by reason of your application, for property orders.
I'm not asking for orders, sir, I just want what's rightfully mine. It belongs to Philip. It does not belong to this court.
You're not seeking orders from me?
Well, I'm seeking orders for my property or whatever you require to do to make sure my property is returned. I cannot trust you, sir. As I say, so many of the laws have been broken, I no longer have any trust in the judge, and that really hurts me, sir. It's scary being in this court with a judge I cannot trust. A judge that cannot uphold the acts, the very acts that I'm supposed to uphold and I'm being here for, but the judges will not uphold those acts, sir. And I've got 64 serious breaches of those acts, and one includes treason from your Judge Maud. Now, as a judge, I've informed you of that your judge on the 16th of July committed treason by stating he had a consent order signed by me. He does not. Therefore, you are a judge, and I would expect you to take action on that, not to ignore it. You cannot have a judge doing that in your court, sir. And I've written to the Honourable Amy Adams, the Chief Justice, about this. And then on the 24th of January, you get a policeman to stitch me up, or someone gets a policeman to stitch me up and try and breach me for protection order 2 years ago.
What's the outcome then of that process?
Well, the outcome is, as I said, he said, oh, you did breach a protection order 2 years ago. That's the case that was heard in front of you. So I've been tried twice for the same thing. There's a new load of police disclosure coming.
What was the outcome of the...
I got 180 hours, 10 years prison sentence he tried to make, and it ended up being 100 hours community service. 180 hours community service, sir, and it's under appeal at the moment. The judge became a witness in the case for some reason. Sir, it's so corrupt. We are scared being in this courtroom today, I tell you. So, sir, I would like you to make orders for my property to be returned, or...
The list of property that you say is to be returned. I'm engaging with you, Mr. Slade, because I want to understand what you want and what direction this is going.
Okay, sir. What I want, I put in the statement of claim.
I've been to listen to you, Mr. Slade, and you just listen to me, okay? So that we don't talk over each other. Say one word with you. I've said to you that there is a fundamental problem with the hearing having been vacated. I don't think I can just rush shot over that. But I want to understand what it is that you are intending to achieve by these proceedings. If it is your intention to relitigate the question of where Michelle is, either certain she is some part of this property exercise, then these proceedings are not going to go anywhere, not in the current court.
Well, sir, I put in a statement of claim to the court as I followed the procedures some time ago, almost a year ago now, and it's been ignored. So we're here today to address all my property, which I've made a list of what I can remember. I'd like that property returned. Sir, is that too much to ask? Is that unclear?
So that's the list of property. Did you get from me, because I think I've seen that list, did you get from me the direction that you were to substantiate the values? Because you were...
That's right, sir, and yet that was very convenient of you to say that, but how can I substantiate the values when everything has been stolen, including the receipts for all the property, sir? It'd be a little bit difficult to produce receipts when you allowed a disgruntled partner to take everything owned in the world, and then you ask me for the receipts. You need to be asking Mr. Chilton Griffiths for my receipts. She has all the property, she has all the documents, she has my birth certificate and my passport and all my relative documents, sir. I cannot produce a receipt. I can't even photograph the property because you have it.
I understand. Well, tell me though, if you had an item that was lost, uninsured, and the insurance company said, establish for us what it was worth, you would say, well, I paid so much for it. They said, well, that's all wrong. What's it worth? Wouldn't you go and price an equivalent item in a shop? Tools and things?
Sir, I would say that was your duty. When you took my property, shouldn't you provide an inventory of what you took? That's what the law required. You need to provide me with an inventory and get me to sign for the property that you took. You just took it, and now you're leaving it 2 years later to make me responsible for accounting for what you took. Sorry, sir, that's not possible. I can't photograph those items. I don't have those items. You have them, sir. You need to take them to the shop and get them valued.
But you know, Mr. Slade, that I only have your property.
Well, that's right, but you gave it to Miss Chilton Griffiths, therefore Miss Chilton Griffiths needs to take it and get it valued. It's impossible for me to do that, isn't it, sir? If I took your car, how can you get it valued? I'm the one that has to get it valued. If I took your saxophones and your granddad's war medals, I'd have to get them valued because you won't have them to get them valued, sir. I don't even know what all my granddad's war medals are to have them valued, sir. And he went to war to protect people's rights and children, sir, not to abuse people. And so what happened to the family group conference? This would have been resolved 2 years ago had that happened, sir, as the law requires. But we dismissed that one out, sir.
Do you have any other papers that you intend to hand up today?
No, sir. I've got all documentation. If we want to go to a high court for this, because it's over $700,000, then I'm happy to file a claim to the high court, sir. I've applied to the high court already. I've applied to court already about your judgment. I've also applied to the high court about my property. Of course, this is the Whangarei court, and it always gets rejected, sir, because there's no justice here, and there's no laws being followed. It makes it very difficult to move forward. And I'm sorry, Judge Hunt, if I'm a little bit upset, but I think you would be upset if someone took all your property for 2 years and threw you on the street, sir. I think you'd be upset too, especially when you hadn't done anything.
Come back to it. I'm hamstrung by the fact, Mr. Slade, and it's unfortunate that as a result of those administrative matters that I referred to, Ms. Chilton Griffiths doesn't. As far as she's concerned, as we speak, this hearing has been abandoned, and I'm not prepared to make orders in her absence, or at least without her being fully aware that today's hearing was to proceed.
So, to me you said, if I don't turn up for a hearing, no excuses, you'll have the hearing without me. How comes Miss Griffiths cannot turn up and you make excuses for her? You've made excuses for her since the 15th of April 2013, her perjury, her lies, her fraudulent documents, and now you're going to say because she doesn't turn up, the court... If she doesn't turn up, that's her prerogative not to turn up, sir, but we can have the hearing without her. That's what the court says.
I can tell you now that the court has also told her and you that I appreciate you won't need to receive it, that today's hearing has
Well, sir, I don't accept that. How can I receive it at 9 o'clock in the morning if I'm on my way to Whangarei, sir? You've had 2 years to send me that notice. You've had weeks to send me that notice.
I'm not representing to you, Mr. Slater.
Well, sir, I don't think that's honest, and I don't think that's fair. I don't think that's honest, and I don't think that's fair, sir. You can't do that to me on the morning of a hearing. I don't accept that. I don't accept it, sir. I think these things need to be done properly and lawfully and legally. I'm here, I was told to be here, and I turned up here, sir. If the other side doesn't turn up, then we have the case without them. And the same as you would have done if I didn't turn up, sir.
The other side didn't turn up, Mr. Slater.
Because a lawyer quit the day before. Well, she should have quit 3 weeks before, sir.
Robinson withdrew a notice issued from this court saying that the hearing was vacated. So, on its face, my seeing you is me trying being aware.
Well, sir, there's more costs I've got to claim for today than making me come all the way to Whangarei. Who's going to pay for that? It's not my fault if it's your court's fault, is it?
Well, that's not the debate I can have with you, Mr. Slater.
No, that's right.
The matter was scheduled for a registrar's review on the 20th of February. Friday.
Sorry.
Mental health on Friday. Can I ask you, Mr. Slater, if I try and accommodate, and understand your sense of grievance about today, if I try and accommodate you by seeing you again on Friday, I appreciate that means another trip, and I'm not about to write you a check for the fuel because it's not within my power to do, so you need to get yourself here by Friday, and probably in the afternoon, and everybody being on notice that the hearing is actually due to proceed. Are you going to persist with raising these issues that, on their face, suggest to me that you don't have any confidence that I should deal with the case? Because if you want to judge you, it's had nothing to do with your case.
I'd like Judge Davis, sir.
Judge Davis?
Yes, sir.
Judge Davis doesn't hold a family court warrant.
Well, sir, is the only judge I trust, or Judge Ellis. They're the only 2 judges I've seen. I've seen a lot of your judges in the courtroom, sir. And the only 2 judges I would trust in this Northland area would be Judge Ellis and Judge Davis. They're the only 2 honourable judges I have met.
Well, I asked that because if you and I are going to spend time doing this exercise, only for you to say, well, I don't trust anything you do anyway.
Well, sir, if you can prove to me that you've upheld the family court law,
It's not for me to demonstrate to you, Mr.
well, sir, then what can I say?
I'm simply asking you, if I make the effort to accommodate you, given what's happened on Friday of this week, is some part of the hearing going to be a review of what I and other judges have done? If you would, I can't.
So there will be a review of 1 judge, and that will be Judge Druce. Judge Druce, the whole reason this property has been held is because he made the orders, and he claims that he has consent. I would like the court, and I've written to the court 32 times under the Officials Information Act for that consent order to be produced. It's not in the Evidence Act. It's not in the bundle, sir. By Joanna, your lawyer, she didn't put it in the bundle, sir. Therefore, it's not admissible. And the second lot of bundles that came into the court, sir, she didn't put it in there either, sir, so it's not admissible. So we would like to see Judge Druce's consent order, sir. We've been waiting almost 1.5 years.
You know, don't
Sorry, Judge Maud,
you
sir.
know, don't you, Mr. Soleil, that what happened that day was that you were represented by counsel. You had a lawyer on the day that...
I sacked him, sir.
Yeah, I know you did. But the fact is that and on that day, he advised the court that you consented to make...
Well, he had no authority to do that. He didn't do it in the court, sir. He did it in the Whangarei court car park, sir. We've got photos and videos of it.
When you read the record...
Sir, the record's to Honourable Judith Collins, and we took photos. They didn't have it in the court, sir. They had it outside in the car park over there, just outside, drinking coffees and lattes. We got photos and recordings, sir. It wasn't held in the court. I only found out about it when I got the judge's minutes.
Right, so the judge said he was told that you consented.
No, well, he did. I didn't consent. And you can bring up the tape of that hearing. The judge would not let me speak in the court, sir. I put my hand up and he said, no, Mr. Saleh. I was not allowed to speak. It's my first hearing, sir. I wasn't allowed to speak. So how could I give him consent if I can't speak?
I'm aware of your inquiries, and I thought the answer to it lay in the fact that Judge, I think it was either Judge Druce or Judge Moore, was advised by your then counsel that you would...
Where was he advised, sir? In the car park? Well, it wasn't in the court, sir, and I challenge you to bring the court tape into this courtroom and play it, and you will not hear the judge mention consent, and you will not hear me speak at all, sir, because I was not allowed to speak in my own hearing. It was all done behind closed doors, sir.
Well, that brings me back to the point that I started was, if you take issue with my sitting on this case, then I preferred that we addressed it on the basis that I didn't then try and accommodate you this week by me setting aside other time and seeing you. If it's still going to be the same criticisms, now you're entitled to take the view you are.
So my criticism, I want my property back. I can't be more specific than that. You have no right to it. Miss Keeling-Griffiths has no right to my property. You have no jurisdiction to my property. So on Friday, will you make the orders for my property to be returned?
I will hear your case, Mr. Slade. That's what I will do.
I have no case, sir. You just took it.
I'm not prepared to promise you what I will do because I haven't heard your evidence. Now, what I'm prepared to do is try and accommodate you this week. But what I'm not prepared to do is start on the basis that at the beginning you say I'm either so conflicted because of something I've done or not done in the past, or because of something you say, some inherent unfairness about the way I go about things, that I can't adjudicate on this issue for you now. If you say, okay, start on the basis that you can adjudicate on it. If you don't agree with the decision I come to, you have rights to appeal. However, I don't want to start putting where you say at the beginning it is inherently unfair because you, Judge Hunt, have decided this thing. You've got a predetermined view about me and everything associated with me.
Well, sir, you did. You had that on the 11th of December last year.
There's the answer to my question.
All you judges have a predetermined thing, sir. It's a game you play. You call it playing the game, living in fear with the lady who makes the complaint, sir. It's well known across the internet. 7,600 cases a year. I've got an army of people that you've done this to, sir. Who are going to be writing letters to the court. You're civil servants. You're supposed to protect us, not the other way around, sir. You're not supposed to harass us, brutalise us, be violent to us, throw us on the street and take our property, sir, and our children. That's not your job.
I can't. Judge.
That's what you did, though, sir.
Judge Davis does not sit in this jurisdiction. Judge Ellis is not a resident judge in Whangarei, so any arrangements made, and judges don't respond to parties' requests to sit on a particular case. Judges are allocated cases as they fall. There's no particular preference. It's your turn to do a case, you do it. It's my turn. I'm responsible for this case today. I will accommodate you on Friday afternoon if you can get yourself back.
So what time on Friday?
It would have to be 2:15, wouldn't it?
2:15, sir? No more tricks, cancelling in the morning or anything like that?
My intention would be to issue it today, but, and this is a very big but, what I want you to do on Friday is focus on the issues as they relate to property, what I can and can't do in respect of property. If we have to deal with questions of the protection order and Michigan and all that went before, then we run the risk that we have.
Oh, sir, I'm running the risk of my life and my daughter, sir. It doesn't matter to you. You just sit there signing your orders over children. My daughter is my life. She is my property, sir. And nothing to do with you, sir. Okay? You had no right to invade my life or my daughter's life, sir. Okay? So we will be going down that issue in the High Court, sir, but I will see you on Friday. I will be here and I would expect you to uphold the law, Mr. Hunt.
You address me as Judge?
Sorry, Judge Hunt, sir.
Mr. Slade. All right, well, I'm going to...
And may I have my documents back, please?
While you're here, I'm going to dictate a minute that covers off what we've talked about today and get that urgently typed back and sent to both Ms. Robertson and Ms. Keeling-Griffiths. And we will have, Friday afternoon, I will endeavour to be in a position to provide you with a ruling before you leave court. I can't make it unconditional because plainly I may hear and see things that I need to go away and reflect upon. But I understand your sense of urgency about getting this tied out. I have to say, this is not my province to govern, but I have misgivings about whether or not the BNZ will accept what you've done. If you can, between now and then, get an acknowledgement from them that the mortgagee action, it's threat, is at an end, and accepted your promissory note, then that would reassure me. But I see what you're trying to say with this bank document, but I just don't think it
well, sir, because of the, just let me explain that. Because of the unlawful nature that the bank are giving loans, and I know that you're aware of this, and Mr. John Key himself is aware of this as a banker, the loans are unlawful. And I'm not going to discuss that today, I'll do this in the Supreme Court. And the fact that the money is created out of fresh air, that they lent me, because the bank were foreclosed in 2012, sir. I have a letter from the BNZ Bank saying we were foreclosed in 2012. Therefore, how can a foreclosed bank lend me the money to buy my house? You can't lend somebody money if you don't have the money, sir. They created the money as it says in that email. They created the money out of fresh air off my signature, then lent me a loan out of fresh air, which they asked me to pay back with hard-earned sweat, cash and labour, my blood and sweat. The bank provided nothing. I asked the bank if I could pay them back in the same manner, sir, and they said, yes, you can, Mr. Saleh. I paid them back in the same manner, sir, and they closed the account.
Well, that's where I'm asking for something from you, because this mortgagee note is dated the 11th of February. Your promissory note is dated 15th of January, 3rd of January.
Well, I haven't received any correspondence from the bank since that promissory note was given to them, sir.
Again, I'll have to register and copy it for you, but the memorandum that Mr. Robertson filed included a mortgagee notice, and it's dated the 11th of February, issued by Sanderson Weir. It says to me the bank haven't accepted.
I think that may be from the debt collection agency, sir.
Sanderson Weir affirmed that the bank's work.
That's right. That's a third party, sir. There's no contract with a third party. We already talked to the BNZ Bank about that. I have my contract with the BNZ Bank, not any third party, sir. We already talked to the bank about that. That's why I paid back the BNZ Bank and not the third party.
Have you seen this memorandum dated 13th February?
Yeah, but we can't take any. We need it from the BNZ Bank, sir. Verification, not for verify. I think you'll find they're called.
It would be worth your while to make a phone call to
Absolutely.
Ms. Robertson and Sanderson Weir and say,
She was notified, sir.
no, you're thinking of the different Miss Robertsons, unfortunately. There's a Miss Robertson who ends for Stuart Griffiths. There's also Miss Robertson, who's different first name, who signed the letter from Sanderson Weir and signed the mortgagee notice for the bank.
Well,
I'm asking you to ring the bank.
I'll ring the bank, absolutely.
Right.
I'm not ringing anyone else. Yeah, I'll ring the bank.
I don't think they've accepted, but it would be good to know, because if you're asking for orders about your home, it's just like...
Yes, I'll get that for you, sir. I'll get it for you.
The home either will be subject to the mortgage, or it will not. And I suspect, in this regard, if you're in a position to get a title search of the details, it looks like there might be a legal aid charge on the equity.
Sir, the court's been paid legal aid as well, sir.
It's been copied.
It's been paid.
In the same way.
So, yep, absolutely. It's legal tender, sir. Absolutely. Same way as you make your bills up, sir, just throw $65,000 at me when you put all the orders on, we can do it back to you, see, sir. It's legal tender, and we're creating the money exactly the way you create it, sir. And I'll stand up in the Supreme Court, and if you can find one thing on that promissory note that doesn't fit the bills of exchange, please advise me, because I've got the bills of exchange right here. That note is completely legal tender, sir.
When are you due at the Supreme Court?
Sorry?
When are you due?
I'm waiting for you to challenge me on my promissory note, because that's where it has to go. Or the bank can challenge me if they wish to, but they haven't. They've accepted it.
No, they haven't. That's what I'm trying to convey to you. Because on the 11th of February...
Under what grounds can they not put... Sir, what grounds can they protest the promissory note?
Because it's not real money, Mr. Sloan.
Excuse me, sir, I can prove to you that it is. Section 3, bills of exchange, promissory notes. 3 forms of legal tender in New Zealand. 1 is bills of exchange. Now, they're not legal tender, sir, because you can't exchange them. 2, a cheque. A cheque you can't use, sir, because you only have credits in your bank account.
Yeah.
You don't have money, okay? So if you monetise a cheque, that's actually fraud. The third form of payment, which is between 84 and 90, is a promissory note, sir. And anyone can create a promissory note, sir. Not just the bank. And I'll show you section 84 here, and my promissory note complies exactly with that. And I wish you would challenge me in the Supreme Court, sir, because we get everybody off their mortgages in New Zealand that are being ripped off by these courts and these banks.
I suppose then you would say you're authorised to create money.
No, it's a promise to pay, sir.
Well, so too was the mortgage. On what basis are you then going?
That's exactly right, sir. The home loan was a promissory note. They call it a home loan, but it's actually a promissory note, sir, on my signature, that they trade on the stock market. And really, that's not the issue for this type of court, sir. This is a family court.
Well, that's my point.
So, sir, you may have a copy of the promissory note, which you do have actually, sir, because I filed one to the minister, and you can take it to your highest court official here, and you can ask him if that is legal tender, and I can assure you he will say yes, it is, sir. So we've had enough of the slavery system, sir, of you taking our children and taking our properties and fining us and doing all the things that you're doing, charging us $65,000 legal aid. I've done nothing wrong in my life, sir, to deserve that. And I'm not just the only person, I'm not standing here on my own, sir. I can tell you half of Northland is behind me on this, sir, and they're going to write letters to this court protesting about this robbery that's happening every day. $65,000, sir, you charged me before I've even been to court. 1st of May, you sent me a bill, $65,000 legal aid to protect myself from something I never did. I represented the money. It's all about the money, sir. It's nothing about the children.
Take a second, Mr. Simone. So you can come back at 2:15 on Friday.
2:15 on Friday. So may I have my documents from you, please?
No, do you take it to the front office and allow them to be copied?
Absolutely, yeah.
And I'll get the registrar and make you a copy of that because I want you to bring some inquiry about that.
And I'm sorry, Judge Hunt, that I'm so uptight, but this has been like over 2 years, sir. And, you know, enough is enough, eh? But at some point.
No, don't give us this. We will copy that one. I've asked to say his documents.
Thank you.
Just a minute. So I'm just going to cover off what was discussed today, just so that set up the basis for Friday's hearing. Just a minute. Slade, the name in front of me is Slade, Kinsey Trends. I record that there were a number of others who wished to be present during the course of the hearing. But in my view, the matter was not such a kind that warranted admission of a number of supporters. Mr. Franklin was a previous McKinsey confirmed the answer, of course, the requirements of the same remaining tenants. Difficulty which has occurred in relation to this matter arises out of a series of unfortunate events. Mr. Slade, in response to the notice of fixture, made application for the waiver of the hearing fee. It was lodged in the Court on about the 4th of February and not transmitted to the Whangarei Court until the 10th of February. It has not been brought to the immediate attention of the judge responsible for dealing with the file. As a result, no waiver of fees and no payment. The matter was further complicated because of a rescheduling that was required in the hearing from 2:15 to 11:45. That direction issued on the 12th of February. When Judge Silsey became aware that the hearing fee had not been filed, she gave a direction dated the 30th of February that the hearing be vacated. Ms. Robertson, who was present counsel for Secure Roberts, was given leave to withdraw. She reported that the matter was adjourned to a registrar's review on the 20th of February at 9 a.m. for Mr. Slade to finalise payment of the filing fee and to make submissions as to any further predictions sought to prosecute his application. She noted that in the event no steps were taken by Mr. Slade, the court would consider striking out his application. That notice was not sent out until today, April 42. I cannot now be certain whether Ms. Secure Griffiths would have attended or not, and as yet she has not. Concerned, however, that space the hearing is vacated. So in that sense, was not able, in my view, to proceed to deal with the proceedings today. Mr. Slade, however, appears in person and is very aggrieved by that. He maintains that he wishes to have the matter received promptly, and there is a long list of complaints as to and concerns as to the process which has occurred so far as the matters arising from the separation of Secure Griffiths is concerned. And further issues as to the arrangements made with Kieran's daughter Michigan relevant to these proceedings, concerns about property which he says is removed from him asked Mr. Slay to make some inquiry of the bank to ascertain what their position is in relation to his promissory note and to confirm whether or not the mortgage has in fact been repaid. I'm mindful of Mr. Slay's disquiet process. He has raised issues today about judicial conduct, including my own. I have made him aware of the possibility that if that concern is to such an extent that he considers I cannot deal with the matter in a balanced way, a balanced or fair way, then I would set aside. I gather from what Mr. Slade said that he would prefer to have the matter advanced, and at least at this point does not take issue with my presiding over the hearing that will follow. I have set aside some time, not otherwise allocated, on Friday the 20th of February at 2:15 for the hearing of this matter. Immediate notices to be provided to Secure the Griffiths. And Ms. Robertson of that. Those make a claim that the matter is to proceed and will proceed in their absence. There's no tenants on their behalf. Or by Ms. Secure the Griffiths or on their behalf. I record for completeness that Mr. Slade did ask that Judge Davis presided, or Judge Ellis presided this matter. Judge Davis, to my knowledge, does not hold appropriate warrants for this jurisdiction, and Judge Ellis is not a judge resident on the road. We'll see as soon as Friday this week could be convened, and the judge wants to be required. On that basis, hearing proceed to Friday 20th February. I do not provide any guarantees to Mr. Slade as to the outcome, nor necessarily will be able to conclude all matters, and it seems to me there are a number of complexities to issues that he has raised. But today's hearing is scheduled for 1 half day only, and we will have at least 1 half day on Friday to commence the hearing and to work towards a disposition of this matter. I remind Mr. Slade, simply because I sense that he regards matters of value as my responsibility, that in the minute of 23rd September I indicated some evidence would be required to substantiate the values, and that it was not the court's responsibility. I'll take it no further than that, and leave it to Mr. Slade otherwise determine what evidence he wishes to produce and how he wishes to make submissions to the court on Friday. Can it be done? Thank you. So, done what I can, Mr. Slade, to accommodate you as quick as I can because of what's happened today. Mr. Franklin, again, if you wish to, you're welcome to attend as a McKinsey friend, same deal, same terms, same conditions on Friday. And if Mr. Slade wants your assistance.
Might I ask you a question at this stage?
Very quickly, Mr.
Yeah, look, I appreciate your patience. Our big problem is, what would you suggest, what should we do to address the first error? He never had a family group conference, things have escalated beyond there. Is there anything that can be done in any way?
It's not my function to provide advice, Mr. Franklin.
Okay, thank you.
It really is something that I would assess Mr. Slade would benefit from some legal advice, but I don't know if it's a question that's been asked of a lawyer. It's not something I can comment on.
Thank you.
So look, you'll get those documents copied for me, so I've got those. Sarah will have a copy of the document that I would like you to have, even if you've already got it, because it's got the, just be careful, the date on it is issues to the dates don't coincide. Your date says you paid on the 13th of January, all right? Your note.
Sorry?
Your promissory note.
19th of January, sir.
It was dated the 15th, isn't it?
No, 19th, sir.
Okay. Just saying about that. That's dated 11th of February, so something's gone awry. It's still carrying on.
Okay.
You haven't paid.
I can find it.
And it makes a difference to the disposition as regards the house. All right, so I'll see you Friday.
Okay.
Just before you go, Philip Soleil at fire.org.nz, is that the right?
No, sir. We've told you, because of your bowels and the things that your ministry do to me and the places you make me live, sir, it's very difficult to have a proper address. My address is now 65 Curtis Road, Rowaney, RD3. My email is philipsally@gmail.com.
2 L's, PHILL.
Yeah, 2 L's, sir.
At
gmail.com.
do you have access to that fire.org address?
Yes, I do, sir, but I say, given the run around I've had for the last 2 years by the ministry, I haven't had a lot of practice in the fire brigade lately because obviously of the circumstances you've left me in, sir.
philipsally@gmail.com.
Yes, sir.
Right. Till that day.
It's a transfer to your Hickory, silence will stand, court is adjourned.